Hi guys, welcome back to Battle with Ola. This is Mujola Olu and I'm so thrilled to be here once again. Today I want to talk about possessory rights and ownership rights over property. I want to talk about this because I find that many people misinterpret these two rights, and many people, assume that they have one when they have the other, or that they have the other when they have one. So let's talk about and differentiate it today. What is possessory right, what is ownership, and does one overlap into the other? How do you get either of the two? That's what I want to talk about today. I want to thank you for all of you that have continued to like the videos, to share the links, to leave me comments, and to leave me houseofministers@gmail.com. I want to make a hearty shout out to all my clients from Battle with Ola, people who have booked paid consultation with me. I'm glad that each and every one of you, we've had amazing and wonderful, consultation sessions, and I do hope that you've been able to make use of the solutions and the results of our consultation. Thank you so much for being my clients. Yes, thank you so much. Compliments of the season to you all in advance. I hope that you have a very Merry Christmas and a Happy New Year. So how do we understand possessory and ownership rights? One, ownership rights means that you are the absolute owner. We have to use the word in the concept. The absolute owner of a property. It could be land, it could be a building, it could be a shop or a block of shops, it could be any landed property. When we call you the owner, it means that you have either bought it by an outright sale or outright purchase now, or that you inherited it and there is no adverse claim to it. It could also be that you were gifted, you were given. It could be that you also got it by partition of an inherited property, So there are different ways to come into ownership of a property. But when you say ownership, when we say you are the owner, it means you have absolute rights over the land. What can you do with the property if you are the owner? One, you can sell it. Two, you can give it out. Three, you can put tenants in it and be collecting rent. Yes, you can make different decisions on the land or on the property. Once you are the tenant, you are the owner, you are also the landlord. Yes, so that's what ownership is. What about possession? Possession means you just have a right of occupancy. Do not misinterpret or conflate it with sea or food. That's not what we're talking about. That means that the period for which you can stay on the property or use the property for a certain purpose, is limited. It is not eternal. It is not absolute. So, and that you have a landlord who is usually the owner, who has given you right to exclusive possession. It could also be limited possession, inexclusive possession. But it means that you are not the owner of the property. You can't sell it. You can't give it out. You can't bring in tenants except the landlord actually gives you permission to do so. So that's what possession is. So let me use the example of a landlord and a tenant. In a landlord-tenant relationship, the landlord has both ownership and possessory rights. But the tenant, once he has paid and the apartment or the building or the property has been rented out to him or leased to him, the tenant or the lessee has possessory rights, not ownership. So the landlord is transferring his possessory rights to the tenant or the lessee, not the ownership rights. What does that mean? It could be exclusive possession or inexclusive possession. But let's talk about exclusive possession. That means that if you have rented a shop, you have a right to use it for the lawful purposes that was agreed to by the landlord, for which you have paid, over the period for which you have paid. So when the period lapses, you either renew the rent or the lease, or the possession goes back to the landlord. But it means that you can occupy the property. When they come and say, who is the owner? You are not the owner, you're just a tenant. And at that point, the landlord is still the owner, but he doesn't have right to ingress and egress at will. That means that his possessory rights, its right to enter the property, has been ceded to you for a time, for a limited period. So even if he, as the owner, wants to enter the property, he has to take permission from you. Where the possession is exclusive, if you have rented a 4-bedroom flat, for instance, you are not the owner, you have rented it, you have to pay your rent to renew the tenancy. So, and that means that you can live in it and use it for the purposes that you've agreed with the landlord. But the landlord cannot just come in and walk into the 4-bedroom flat because he's the owner. No, he can't sell it without recourse to you. No, he can't give it out without recourse to you for the period for which you have paid. the landlord has to carry you out over everything that has to do with the possession of that house. So if he wants to maybe show it to people that want to buy it, he must tell you. They can't just come into your house and say, oh, we are prospective buyers, the landlord wants to sell it, we are looking at it. No, they must inform you as the tenant. So you have to give them permission that, okay, come in, look at the property. Or don't come in, or I won't be around this time, come at this time. That is possession. So you are not the landlord, you are not the owner, but you have exclusive possession. Even if the landlord wants to come in, he has to tell you that, okay, I want to come in. Maybe I want to come in to examine a fault. I want to come in to maybe assess it. I understand that in some jurisdictions, the landlord pays like some a form of visit, inspection, you know. The landlord inspects the property from time to time to see how the tenant is using it. So even if he wants to come, he has to notify you that, okay, I'm going to be having inspection visit at this time, so that you can open the door for him to come in. But if you shut the door and say you cannot come in, he cannot come in except with your permission. That is what possession means. So a tenant has the possession, the landlord has the ownership. Let's differentiate it further. 1, ownership you can sell, possession you cannot sell. 2, ownership you can give it out, possession you cannot give it out. 3, ownership you cannot come in once you have given possession to someone. You have both, ownership has both ownership and possession. But once the ownership has been given to someone for a particular time, the owner cannot come in at will, ingress and egress at will. It has to be subject to the permission of the possessor. So, but for possession, you can come in and come out at will, except when your possession has lapsed and you have not renewed it, you know, by payment of an agreed sum. So that's ownership and possession. This topic is very dear to me, and I thought to make this video because I see that for many of my tenancy disputes these days, some landlords do not understand what it means to cede your possessory rights to your tenant for a limited period. I find that sometimes the landlord has ceded the possession, but he's still saying, oh, I can do another. For instance, I had a case where the landlord used to do some form of religious ritual, and then he would still march around the flat of the tenant doing that ritual. And the tenant was like, I have rented this apartment and this portion of the compound. Don't come around my place doing this ritual. The landlord was saying, you only rented a flat, you didn't rent the entire compound, so I can do and undo. No. If he has rented a flat and the flat is in a compound, he also has rights to the front and the back, the sides of his building that are on his side. That's just lawful. You should respect that as a landlord. And then the tenant also complaining that when you're making these rituals, you're always making noise. So I don't need this noise. I have children. My children are always complaining that, oh, daddy, they've started again, this and that. The landlord was like, no, we are praying. We are praying. It's a religious instruction. So you can't tell us what to do in our property. No. If you have given your house out, if you have given the possessory rights to your house out for a limited time and you have gotten value for it, you enjoy that value and allow the tenant to also enjoy, what they've paid for, which includes, a right to peaceful and quiet enjoyment of their property. I've done a video on tenants. It's about 3 videos. A tenant must have right to peaceful and quiet enjoyment of the property that they have rented. Very important. I've also had a case where, the landlord would go into the tenant's house and say, look at your kitchen, everywhere is jam-packed. What are you doing here? What are you doing there? Removed light bulbs on the side of tenants and said, because you are not turning off the light bulbs, we are going to remove it. All these things. Please, if you're a landlord, especially in Nigeria, once you have given out your possessory rights and you have gotten money or value in exchange for it, allow the tenants to enjoy peaceful and quiet possession of that property until they give up the property. Another thing that I keep encountering is the case of tenants who carry out major renovations. Now, we were differentiating here ownership and possession. For ownership, the owner can carry out whatever form of repairs on his property, whether major repairs, minor repairs, But when he has given possession to a tenant, tenants can carry out minor repairs, especially the ones that were caused by his possession of the property. But for major repairs or alterations to the property, there must be recourse to the landlord. Because I find that most tenants carry out major repairs, renovations of the property, and when they are leaving, or when the landlord now says leave suddenly, and after the lawful period, they now say that, oh, why were you waiting for me to carry out these renovations? I painted the house, I brought in electricity, I did this, I did that. No. If you're carrying out major repairs or renovations to the property, it must be with the consent of your landlord. Now, the law is that the landlord should give you the property in tenantable condition, that is in a condition where you can live in it as a tenant. But if there are major repairs or renovations to be done, you should inform him, and he should do it as is prescribed by law. But where you want to do it, or where he's saying he's not doing it, he can give you permission in writing, saying do it. When you're leaving, you can remove it, or I will refund you. It must be in writing. Please check your agreements when you're signing tenancy agreements. And even if it's not in your agreement, make sure that you insist that the landlord gives you written permission. There's another matter that came before me for mediation, where the tenant had carried out major repairs because it was supposed to be a business premises, because the property was to be used as business premises, and clearly anyone who gets to that property would agree that the state in which it was rented out to the tenant, the purpose or the object of business of the tenant cannot be rightly carried out or conveniently carried out, so he had to carry out those major repairs. But the landlord insisted that he never gave him permission. Millions of naira have gone into repairs, and now the tenant is left without any solution, because the landlord is saying, I might even compel you to restore my property to how you met it, because I never gave you permission. Now, the landlord also has written letters which he claimed to have served the tenant to the effect that he had instructed the tenant to make sure that whatever renovations he's doing to make the property compatible with his business purpose were done with reusable materials, temporary materials in a temporary form. But the tenant had done permanent, repairs, and now it was just the option of refund me what I've used. Landlord is saying restore my house to how you met it. Tenant is saying refund me the expenses for renovating this property, because I told you what I wanted to use it for. What I'm saying is, please get written permission if you're making major repairs. If you're changing the roof of your apartment, or if you're fixing, major things that will pain you, if they say move out and go now, get a written permission that says that we are going to refund you, or you have permission to remove these things when you're going, and restore the house to how you met it. But always have it at the back of your mind that the law is that you must restore the house to the state in which you met it, the closest to the state in which you met it when you were living, and that the landlord should also give you that house in a tenantable condition. So these interests must be balanced. But what I'm saying is that as a tenant, your rights are limited. As a landlord, once you cede your possessory rights, your rights become limited, no longer absolute. If you want to sell the property, you have to inform the tenant that has paid you and is living or using the property. You have to give them adequate notice to put their house in order before you can sell the property. Another thing is that a tenant cannot let out the house to a subtenant except by the permission of the landlord. So you cannot just rent out the property. Even if you're moving out, you can't say, my tenancy I'm left with maybe 6 months, I'll put a tenant in it and collect my money back. If the landlord, if you don't have that agreement or understanding with the landlord, the law is that you are not the owner. You cannot let or sublet without the express permission of your landlord. So let this interest balance out in whatever you're doing. But essentially know that ownership is greater than possession any day. Ownership will trump possession. The owner also has the possession, but he can give it out for a limited period. And of course, it can also give out ownership by an outright sale or by a gift, by giving it out, by a deed of gift. It can give out the ownership. So both rights, ownership, possession, are transferable. And those are the competing interests when transferring one or the other. That's what I wanted to discuss in this video. Please watch all the other videos I've done on tenancies so that you can understand, because this video is most applicable to tenancies. I'll see you in my next video. Please don't forget to subscribe, and don't forget that if you need a paid consultation where the legal solution you require is not one that can be answered in 1 or 2 lines, it's something that needs to be delved into comprehensively, you can book a session with me. The link to book is it's a paid session. The link to book is in the description box, or you can mail me at House of Livingstone so we can make an arrangement. Don't forget to subscribe. Toodles.